Hello and welcome to TaxPundit.org. TaxPundit is India's most popular and trusted database of income tax case laws. In today's video, we will be analyzing a landmark case study that provides critical insights for tax professionals. Let's dive right into the details. The case under discussion is M SOUHARDA PATTINA SAHAKARANYT vs. Income Tax Officer, pronounced by Bangalore Tribunal on the 28th of April 2026. The Assessee, a credit cooperative society registered under the Karnataka Souharda Sahakari Act, 1997, filed its return for assessment year 2017-18 declaring total income of Rs 17,07,220 and claiming a deduction of Rs 1,42,62,849 under Section 80P 2(1). The assessing officer denied the deduction solely because the assessee was not registered under the Karnataka State Cooperative Societies Act, 1959. Additionally, a disallowance of Rs 69,208 was made for non-deduction of tax at source. The CIT appeals upheld the denial of deduction, relying on the Supreme Court's decision in Mavilayi Service Cooperative Bank Limited, 2021, holding that interest income from non-eligible entities is not deductible. The assessee appealed to the ITAT. The tribunal first addressed whether a society registered under the Karnataka Souharda Sahakari Act, 1997 qualifies as a cooperative society under Section 2(19). It relied on the Karnataka High Court decision in Government of India Ministry of Finance vs. Karnataka State Souharda Federal Cooperative Limited, 2022, which held that such a society is a cooperative society under Section 2(19) and entitled to Section 80P benefits. The tribunal stated the AO's stand was not correct. The tribunal distinguished the Mavilayi decision on facts. It noted that the assessee is engaged in business with its members, and there was no evidence that the assessee dealt with non-members. The CIT appeals is finding that the assessee earned interest income from non-members was without any basis. The Mavilayi decision itself states that if the assessee is engaged in business with members, the deduction cannot be denied. The tribunal held the issue is covered by Karnataka High Court decisions in Todgar's Cooperative Sale Society, 2017, and Tumkur Merchants Souharda Credit Cooperative Limited, 2015. These decisions hold that income attributable to providing credit facilities to members, even if mixed with non-member transactions, is allowable under Section 80P 2(1). The deduction is not lost merely because the society is registered under a different state act. The tribunal held that the disallowance of Rs 69,208 for non-deduction of tax increases the income of the assessee, which is attributable to the business of providing credit facilities to members. Therefore, any such disallowance would simultaneously increase the deduction under Section 80P 2(1). The tribunal directed the AO to allow the deduction on the enhanced income as well. The tribunal noted that the assessee had not claimed interest income under Section 80P 2(d), but treated the entire income as business income attributable to its business. Consequently, the tribunal held that the issue of denying deduction under Section 80P 2(d) does not survive for subsequent years. The ITAT's decision is a significant victory for cooperative societies registered under state-specific acts like the Karnataka Souharda Sahakari Act. The tribunal reaffirmed that such societies are entitled to Section 80P benefits, provided they are engaged in business with members. The ruling clarifies that Mavilayi does not automatically deny deduction, it only applies where there is clear evidence of business with non-members. Question: what is the key takeaway from this ITAT decision? Answer: the key takeaway is that a cooperative society registered under the Karnataka Souharda Sahakari Act, 1997 is a cooperative society under Section 2(19) of the Income Tax Act and is eligible for deduction under Section 80P 2(1). 1. For business conducted with its members. Question. Does the Mavilayi Supreme Court decision apply to all cooperative societies? Answer. No. The ITAT distinguished Mavilayi by noting that it does not deny deduction for business with members. The deduction is only denied if there is evidence of business with non-members. In this case, there was no such evidence. Question. What happens to the disallowance for non-deduction of tax? Answer. The tribunal held that the disallowance increases the business income, which is eligible for deduction under Section 80P 2(1). Therefore, the AO must allow the deduction on the enhanced income as well. Question. Can a Souharda Cooperative Society claim deduction under Section 80P 2(d) for interest income? Answer. The tribunal noted that the assessee did not claim interest income under Section 80P 2(d), but treated it as business income. Therefore, the issue of denying deduction under Section 80P 2(d) does not arise in this case. Question. Is this decision binding on other ITAT benches? Answer. While ITAT decisions are not binding on other benches, they have persuasive value. The decision relies on binding Karnataka High Court precedents, which are binding on authorities within Karnataka. Thanks for watching this video. You can download the full legal analysis, the official case law, and a concise case digest PDF directly from our website, TaxPundit.org. If you have any questions, feel free to write to us at TaxPundit@TaxPundit.org, or message us on WhatsApp at 9326306668. Don't forget to subscribe to our channel for more authoritative legal updates.